people are of the opinion that when someone is actually on a sick bed, or when people are actually of a certain age, probably age 80, 90, that is when they should write a will. That is incorrect. Okay, we have it in back to my YouTube channel. Thank you so much for tuning in. I do appreciate you. If you're a returning subscriber, thank you for always coming back. If you're a new subscriber, I appreciate you. Thank you for subscribing. And if you're yet to subscribe, what are you waiting for? Click on the subscribe button. Okay, my name is Mary. I'm a practicing lawyer in Nigeria, and also I'm a real estate consultant. And on this channel, I share videos for laymen and also for lawyers. In today's video, I'll be answering some questions about will. And some days ago, I actually shared a video about importance of will, and in today's video I'll be answering some questions such as when can a person write will, 2, what happens when a person dies intestate, and number 3, what makes a will valid. So I'll be answering those 3 questions in this video. If this seems like something you're interested in, you know what to do. Please make sure you watch this video till the end. The first question, when can a person write a will? Some people are of the opinion that when someone is actually on a sick bed, or when people are actually of a certain age, probably age 80, 90, that is when they should write a will. That is incorrect. Okay, we have it in Nigeria that once you are 18 years and above, you can write a will. So to the question, when can a person write a will? If you are 18 years, you have a sound mind, that is the second point. 3, if you have acquired assets, you can write a will. If you are 18 years, you have a sound mind and you don't have assets, there's nothing to actually say that you want to distribute upon the person's demise. Okay, so if you're a sound mind, you're 18 years and you have assets, okay, be it just one property, even if it's just a piece of land, you can write a will. Okay, it is important that when you have those 3 things, you're actually good to go to write a will. You don't need to wait till when you are age 80, you don't need to wait till when you're on the sick bed, God forbid, but you don't need to wait till any of those situations before you can write a will. Second question, what happens if a person dies without a will? That is, the person that died intestate, that is what we call it. Anybody that died without a will has died intestate. So here, there is no will. How do the wife, the children, how would they share the properties? Yeah, the properties can be shared using either of these 2 methods. Okay, and it depends on certain factors. Certain factors will actually determine how the person's estate will be divided. Okay, number 1 is it is possible for those estates to be divided according to the customary law or Islamic law. That is 1. And number 2 is the administration of estate law of the deceased state. That is where the deceased actually died. The state is this lived and died. Okay, not where it originated from. So it is possible for a man to actually originated from Oyo State and actually lived in Lagos State. Do you understand? So the administration of estate law of Lagos State will be applicable. So here we have 2 ways. We have the customary law or the Islamic law, or the second aspect is the administration of estate law. So in a situation whereby somebody died without a will, how would you know which of this method to use? So if that person actually contracted a marriage under the Marriage Act, what people call court marriage, the administration of estate law will actually be applicable of that state where the person lived. Okay, not where he originated from. But if that person actually did not contract a marriage under the Marriage Act, if all that person actually contracted is actually a marriage according to custom or custom or this nikah Islamic law, that person's estate will be divided according to the custom. Okay, according to the custom of that person. So in a situation whereby a man died intestate and is actually an Igbo man, I made a video about this barbaric Igbo custom, the barbaric Igbo custom that says a female child cannot inherit from her late father's estate. So in that situation, the custom of that man will actually now be implied on the estates, which is actually one of the importance of you writing a will. Because in a situation whereby an Igbo man died intestate, people, the uncles, the relatives can actually say no. As a female child, the child does not have a right in the late father's estate. I think I've addressed that in my previous video about the importance of writing a will. Okay, in order not to deviate from the question that I was actually answering, how would the estate of a man who died without a will be shared? So if what you just need to understand is what kind of marriage does that person contracted. Okay, if the person have a wife and children, what kind of marriage that the person contracted? If the marriage under the Marriage Act, the administration of estate law of the state where the man died will be applicable. If the man did not contract a marriage under the Marriage Act, the custom or the Islamic law will be applicable. Okay, so if it's Yoruba, so I know a bit of how property is being distributed in the customary, using the customary law of Yoruba. So you see this issue of Dawood, that is the eldest son. So it is possible for a man to actually have a child. The first child should be a female, but they will actually give more to the eldest son. Okay, and you see this Oriojori Idigi. The Oriojori is that the children are equal. Okay, and the Idigi is that according to the number of children. No, according to the number of wives. Okay, so in a situation whereby you don't have a will, the person died intestate. If the person contract the marriage under the Marriage Act, the other option will be applicable, that is administration of estates according to the law of where the man died. Okay, and if the person actually contract the customary marriage, did not contract that marriage, the other one will be applicable. So that is basically what will happen if someone died without a will. So it is important for everyone that have assets, everyone that is of a sound mind, everyone that has clocked the age of 18 or above, to write a will, to avoid this issue of using the customary way of the thing to actually distribute property, which may not actually not come out well, because a lot of litigation will actually happen as relating to that. So that's aside. So what makes a will valid? We'll be talking about will. It's not just for you to write a will and say, okay, this is how I want my property to be distributed. For a will to be valid, there are a lot of things that will be put into consideration. In this video, I'll be mentioning about 8 or 9. So the first one is that will must be in writing. Okay, there are actually exemptions to that, but I'll be saying it later. So number one is, if you want a will to be valid, because it is possible for someone to write a will, and it is possible that upon the person's demise, the court can actually say the will is invalid. Okay, based on certain things, such as if the will was not made voluntarily, or that person was not of a sound mind when that person writes when the person wrote the will. Okay, so number one is the will must be in writing. Number two, it's that person will be of a sound mind. I've mentioned that earlier. And number three, the person must be 18 years or above. 4, it must be signed by the testator. The testator means the writer of that will. Okay, number 5, it must be witnessed. It must be witnessed. That people must actually be, there must be witnesses, and it must be signed by those witnesses, and minimum of 2 witnesses. That is important. So number 6, that relates to the issue of witnessing, is that the beneficiary, that is those people that actually that's been put in the will. Okay, Adebisi should take 2 plots of land. Those person, that Adebisi, must not be a witness. Okay, it can actually invalidate that will. So that person must not be a witness. That is number 6. Number 7 is that the spouse or the partner of the testator, that is the person that is writing the will, the spouse cannot be a witness. It is possible for the spouse to be a beneficiary, and it is possible that the wife will not be a beneficiary, it will not be the children. So it is important that such person should not be a witness to that will. Number 8, the beneficiaries must be named. All the beneficiary names must be in that will. And another thing is that the properties to be shared must be identified. That is also important. So those are the 9 things that actually make a will valid, that makes a will valid. So let's talk about the exception. The exception to the rule that a will must be in writing, and also that a person must be 18 years before such person can write a will. So there are actually certain persons that are actually exempted from this general rule, which are the sailors, the armed forces. So they are actually exempted from this particular rule, I think because of the nature of their profession. So the law actually permits them to write a will before the age of 18. Also, it is not compulsory for that will to be in writing. So this is not all about will. I'll be coming up with subsequent videos on will. I hope this video educates you. Please do not forget to like, comment, and subscribe. By liking this video, to help me that the algorithm will actually make my videos to reach a wider number of people, and so doing I'll be able to reach the 4,000 watch hour. I'm yet to actually be monetized, and I've been putting a lot into this YouTube channel. So please do well to like and share this video, and I will see you in another video.